If you found an old parking ticket, you might wonder how long you can be chased for it. The answer isn't a straightforward 6 years. There are a few layers to it, which I'll go into. Penalty charge notices, which are issued by local councils for parking violations on public land. Ignoring this ticket can lead to legal action. The local authority can increase the fine and may ultimately take court action to recover the debt. This can include sending bailiffs if the debt remains unpaid after a court order is issued. The 6-year rule wouldn't necessarily work for this type of ticket because they're very persistent to chase for the fine. However, if your penalty charge notice went under the radar and 6 years has passed, then you can no longer be taken to court for it. Parking charge notices issued by private parking companies for violations on private land follow a 6-year enforcement period, and if unpaid, these companies can pass to debt collection agencies or take you to court to obtain a county court judgment, that's a CCJ. Now, this can impact your credit score for up to 6 years, affecting your ability to get loans or mortgages. There are specific time limits for receiving parking tickets. Local authorities typically have 28 days to issue a penalty charge notice, which can extend to 6 months if there are delays in retrieving your details from the DVLA. Private parking companies must issue a parking charge notice within 14 days of the violation if it's sent to you by post, or have 56 days to send a notice after leaving your ticket on your vehicle. If you receive a parking charge notice from a private company and don't pay, the company can escalate the situation by sending reminders involving debt collection agencies and eventually taking you to court for a CCJ. This can add extra costs and stress, so it's crucial to either pay the fine or challenge it if you believe that it was issued unfairly. Bailiffs can get involved for unpaid penalty charge notices, but only after a court order is issued and the 21-day time limit's passed. They must give at least 7 days notice before visiting your property. Even at this stage, you can still appeal or request breathing space to seek debt advice, giving you 60 days without additional charges or interest. You can challenge a court order if you have valid legal grounds, like not receiving the original notice or already having paid the ticket. To do so, you need to fill out a form, it's called TE9, and keep a copy for your records. It's best to address a ticket promptly to avoid complications. If you think you have grounds to challenge a parking ticket, then you can appeal. For a penalty charge notice, you can make an informal appeal within the first 14 days or a formal appeal within 28 days, supported by evidence. The council usually responds within 56 days. For private parking charge notices, the process varies, but generally involves submitting an appeal within 28 days. If the issuing authority doesn't respond within 56 days, then you win the case by default. Ignoring a parking ticket can lead to serious consequences. Local authorities and private companies can take legal action to recover the debt, which can result in increased fines, court costs, and impacts on your credit rating. Always address parking tickets quickly by either paying or appealing to avoid these outcomes. If you're looking to appeal and you're unsure whether it's likely to be successful, then you may want to chat to a professional. Online solicitor JustAnswer runs a £5 trial, and you can ask as many questions as you want in that chat. If you use a link that I've left you below this video, you'll be supporting their advice service, so thank you.